I'm delighted to be talking to you all. And what I wanted to do today is I wanted to try and connect what we talked about last year, those of you who were with us last year, and do so in a way that the people that are new to our group will not have missed anything. And I wanted to connect it to what we are seeing now on the court that we will be analyzing on August 8th in the second of these court review webinars. And the way to do it was to put together some thoughts about how I had to deal with this problem last year in teaching about these cases and about what the court has done. And I think that this is the perfect audience for this address. The full title is Teaching Constitutional Law Then and Now, Understanding the Supreme Court's Transformation from the Making of the Nixon Court to the Unmaking of the Roberts Court. And hopefully that will become clear as I go through. This should be about 45 or 40 or 50 minutes long, and I would be very happy to take questions afterwards. I first studied constitutional law at the University of Massachusetts over half a century ago, between 1971 and 1973, under the tutelage of a legendary teacher, Professor Dean Alfange, who sadly passed away earlier this year, and we just memorialized. In Dean's constitutional law classes, which were legendary on our campus at the University of Massachusetts, we studied roughly 24 classic Supreme Court cases each semester, as opposed to the 75 to 90 cases that I teach now, exploring a different topic each week. He taught us that the United States Supreme Court made decisions based on law and precedent when an old precedent had to be reversed, such as Plessy versus Ferguson's separate but equal doctrine, and needed to be in the 1954 Brown v. Board of Education case. It was only after the court laid an extensive legal groundwork to justify the new legal interpretation and had used the logic of their opinions to persuade the general public of the decision's correctness. Professor Alfange taught us about the twin values of stare decisis, or respect for precedent, and the merits of judicial self-restraint, with justices reaching only so far in their rulings as necessary to resolve the case before them. He used these concepts to explain how the liberal 6-3 justice supermajority of the Warren Court used judicial activism, expanding the reach of the Constitution by reading precedents in such a way as to enlarge the constitutional protections for marginalized people. And that was the danger that Dean Alfange saw decades before it happened. As much as he seemed to us to appreciate the results of the Warren Court, Dean showed his liberal college students of the 1970s the hazards of employing judicial activism, going beyond the precedents and proper textual analysis to promote changes they wanted to see in the law. Like other scholars of that generation, Dean taught us about the Warren Court era using the intellectual lens of the 1937 constitutional battle between Franklin D. Roosevelt and the Supreme Court's 9 old men under Chief Justice Charles Evans Hughes. FDR, frustrated by not having the opportunity to appoint a single Supreme Court justice during his first term as president, and seeing his New Deal legislation continually struck down by the Hughes Court, proposed adding up to 6 new members to the high bench, which he hoped would allow him to appoint sufficient justices to uphold his legislative agenda. His proposal was obviated by Charles Evans Hughes's and Owen Roberts's reversals of their previous decisions, the so-called switch in time that saved 9, to become deferential to Congress's economic legislation. Hughes and Roberts acted as politicians instead of judges, trying to save the status quo by abandoning it. Dean told us that shortly afterward, Harvard constitutional law professor Thomas Reed Powell came to class carrying an armful of enormous constitutional law casebooks, dramatically walked over to a large trash can, and dropped them into the large can, saying, "Nothing is the same in my field anymore." I know that feeling. Does this sound familiar to any of you after what you read from the Roberts Court in June of 2022 and what we are seeing so far this term? Dean's students did not realize that at the time that he was teaching us these lessons, we were living through the next constitutional generational regime change in the Supreme Court's history, the course of which has resonated throughout my entire academic career and does so still. In reaction to the work of the Warren Court, the independence of the Supreme Court came under fierce political, press, and public attack. There were "Impeach Earl Warren" signs all through the South, on billboards. In 1968, when Chief Justice Warren announced that he would retire, and President Johnson announced that Justice Abe Fortas would replace him, the conservative Senate Dixiecrats in the Democratic Party, led by Strom Thurmond of South Carolina, combined with the Republicans to filibuster the nomination and defeat it. They were aided by leaks about Fortas's ethical challenges from former Vice President Richard Nixon's presidential campaign team. The following year, Fortas resigned after the Nixon Justice Department leaked information to the press about a financial scandal involving Justice with a fund set up by a Florida financier named Lewis Wolfson, who was then involved in a court case headed to the Supreme Court. Now, President Richard Nixon had two vacancies to fill, eventually appointing Chief Justice Warren Burger, and after two Nixon appointments were defeated by the angry Democratic senators using similar charges of lack of ethics and intelligence, Associate Justice Harry Blackmun was seated. Unsatisfied with that level of change, Nixon directed his Justice Department under Will Wilson to try to rid him of the liberal icon, William O. Douglas, so that he could replace him with another conservative. Will Wilson, who was an assistant attorney general in the Justice Department, leaked the FBI's entire file on Douglas to Republican Congressional Minority Leader Gerald R. Ford, detailing Douglas's involvement with a financier in Las Vegas named Albert Parvin, who had alleged organized crimes connections. As a result of Ford's speech on the floor of the House based on this file, impeachment charges were leveled against Douglas in 1970. Unlike Fortas, the feisty Douglas had no intention of resigning and was ready to fight. And he told Attorney General John Mitchell, who was threatening to have him removed from the court, "Well, saddle your horses." These charges were bottled up in committee and defeated in the Democratic-controlled Congress. But nature took its course, and more court change came in the fall of 1971. Two other ailing justices, John Harlan II and Hugo Black, left the court within 5 days of each other in September, giving Nixon two more slots to fill, which he did with an ultra-conservative William Rehnquist of the Office of Legal Counsel and Virginia moderate conservative lawyer Lewis Powell. All four of Nixon's appointments had strong conservative credentials. By working alongside conservative Kennedy appointee Byron White, the 6-3 liberal Warren Court was transformed into a 5-member ultra-conservative majority. Roosevelt appointee William O. Douglas, Eisenhower appointee William Brennan, and Johnson appointee Thurgood Marshall remained on the liberal side, while Eisenhower appointee Potter Stewart held down a more moderate position. But despite their ideological political philosophies, all of these justices were still institutionalist-oriented. They were what are called now neutralist justices, who adhered to the civility and nonpartisan norms of the court. They could, for the most part, work as judges who respected the rule of law, precedent, and each other. Some proof of that is that the Nixon Court, despite its conservatism, still decided cases with moderate to liberal results on occasion. One disallowed prior censorship by the press, allowing the publication of the Pentagon Papers in the New York Times versus United States case in 1971. Another upheld using school busing to integrate public schools in Swan versus Charlotte Mecklenburg Board of Education, also in 1971. And a 7-2 majority upheld the right of women to choose to have an abortion in 1973's Roe v. Wade case. And despite Nixon's 4 appointments to the court, the justices unanimously disallowed his claim of executive privilege to hide in the Oval Office audio tapes during the Watergate scandal in U.S. v. Nixon in 1974. These cases were all politically charged and much debated in the public square, but the justices decided them based on law and not on partisanship. After the Fortis controversy, the justices limited their off-the-court work to deciding cases and issuing opinions, not doing any extrajudicial speeches or appearances outside of the court's work. However, we did not learn until Linda Greenhouse's masterful book on Harry Blackmun that he and some of his colleagues were secretly leaking information against Chief Justice Burger, who had lost control of his court, to Bob Woodward and Scott Armstrong in their investigative masterpiece, The Brethren. When President Gerald Ford succeeded Nixon, he was allowed a single nomination to the court, John Paul Stevens, to replace the retiring liberal icon William O. Douglas in 1975. Ford would later reflect that he wanted to name to the court the most able justice and someone of complete integrity, not necessarily someone who agreed with his particular ideological bent. By the end of his career, Stevens and Blackmun were among the most liberal justices to ever serve on the high bench. Clearly at this time, justices did not feel confined to promote from the bench the political views of their nominating presidents or the political party, the definition of being nonpartisan. In 1976, Jimmy Carter was elected president and had no vacancies to fill on the Supreme Court during his 4-year term. So the court remained static until 1981, when President Ronald Reagan appointed the first woman to the court, as he had promised to do in his campaign, Sandra Day O'Connor. O'Connor was another non-ideological institutionalist. She was a neutralist judge. During the latter part of the 1970s through the mid-1980s, the court as a whole remained a target of political attacks, but continued in the neutralist approach, upholding affirmative action in college admissions in Regents versus the University of California versus Bakke in 1978, and establishing what is known as the Chevron deference doctrine in Chevron versus National Resources Defense Council in 1984, which laid out a test of when to defer to an executive administrative agency's statutory interpretation, so long as it was not unreasonable and Congress had not spoken on the specific question at hand. In 1986, Chief Justice Warren Burger submitted his retirement from the Supreme Court, initiating a game of musical chairs on the court. President Reagan nominated Associate Justice William Rehnquist to serve as chief, and to fill Rehnquist's seat, he nominated the first Italian-American to the court in history, Circuit Court Judge Antonin Scalia. This latter appointment, I would argue, is the spark that lit the fire of partisanship of the Supreme Court in the latter part of the 20th century. So much so that only 5 years later, Justice Thurgood Marshall said in his valedictory opinion just before he retired, "Power, not reason, is the new currency of this court's decision-making." When moderate Anthony Kennedy, rather than ultra-conservative Robert Bork, took moderate Justice Lewis Powell's seat in 1987, O'Connor's centrist legal approach was given a chance to bear fruit. But that was not Antonin Scalia's long-term goal. When choosing Scalia, President Reagan believed his nominee would unite the court's conservative wing into a cohesive voting bloc. He was told by his assistants that Scalia would become the William Brennan of the right wing. Just as Brennan had united the Warren Court, Scalia would do the same for Rehnquist and the conservatives. But Scalia had other ideas and did just the opposite. From the moment he arrived, Scalia challenged the institution's norms. Instead of deferring to his senior colleagues during oral argument, he dominated them, striving to prove that he was their intellectual equal, if not their superior. "Do you think he even knows that the rest of us are here?" Lewis Powell whispered to Thurgood Marshall in the middle of one of Scalia's multiple questioning periods. And rather than wait for the Chief Justice to assign him his first opinion, which would be an easy, routine, unanimous opinion, in the very first case of the term, he tried to steal a majority opinion from Sandra Day O'Connor dealing with the inheritance rights of Native American tribes. He did this to the anger of many of the senior justices on that court. Scalia further damaged the conservative wing's cohesion by driving moderately conservative justices toward the political center. He ridiculed one of Justice Sandra Day O'Connor's opinions as being, quote, particularly perverse, irrational, and cannot be taken seriously. Scalia later berated Justice Anthony Kennedy, who was appointed to the court in 1988, dubbing one of Kennedy's opinions as incoherent and as infinitely expandable as the reasons for psychotherapy itself, among other insults. While neither O'Connor nor Kennedy took public exception to Scalia's incivility, O'Connor almost never voted with him again in any significant social issues case, and Kennedy consistently voted against Scalia on the death penalty, prison rights, presidential power cases, and eventually even Obamacare. After failing to bully moderate conservatives to his side, Scalia devised a different strategy to promote his brand of conservatism. Despite existing norms from the Fordist period against extrajudicial speeches by justices, Scalia devoted the summer of 1989 to writing 2 talks that he would later turn into influential law review articles. In them, he called himself a faint-hearted originalist, unwilling to upend long-standing precedents with which he disagreed. And then he outlined his philosophy for deciding cases: textualism and originalism. The former, textualism, was the study of the language of the Constitution and its amendments using Noah Webster's first American Dictionary of the English Language, a book published in 1828 in Paris, over half a century after the Declaration of Independence. The latter required immersing oneself in political and the intellectual atmosphere of the time, as Scalia said, supplementing Webster's dictionary with early historical materials such as diaries, letters, newspapers, and speeches. Scalia admitted that this originalism and textualism task was sometimes a better task suited for the historian than the lawyer. Although Scalia was reportedly an amiable colleague on the court, he was never a consensus builder on the bench. As a result, he was often in solo dissent. He dissented in 11 straight cases at the end of the 1995-1996 term. Every few years, tired of losing big cases, he would abandon any attempt at civility and lash out at his colleagues. In a gay rights case from Colorado, Romer v. Evans, Kennedy ruled that stripping gays and lesbians of local protections against discrimination with a state constitutional amendment that was, quote, born of animosity, violated the Equal Protection Clause because, Kennedy said, it deemed a class of persons a stranger to its laws. Scalia dissented vigorously, accusing Kennedy of exhibiting terminal silliness. And when his good colleague and friend, Ruth Bader Ginsburg, added women to those who could apply and attend the Virginia Military Institute, Scalia accused her of writing an opinion that was politics wrapped in law. At the end of that 1996 term, Scalia complained that his judicial colleagues were, quote, day by day, case by case, busy designing a constitution for a country I do not recognize. And then he wrote retired Justice Harry Blackmun, I am more discouraged this term than I have been at the end of my previous 9 terms up here. I'm beginning to repeat myself, and I don't see much use in it anymore. He thought about retiring in 1996, and then he thought about retiring again early in 2000 if Al Gore won the presidency. But Scalia stayed on the court to achieve perhaps his greatest political success by persuading Anthony Kennedy to support George W. Bush's cause in the landmark case of Bush v. Gore. Thereafter, he would abandon his textualism and originalism whenever they did not help him reach his desired result, and he would speak injudiciously about his colleagues and the disputes that came before them. 3 years after Bush v. Gore, Scalia and Kennedy clashed when a 5-4 majority overturned a Texas law banning intimate relations between same-sex couples. Kennedy wrote that states could not reasonably regulate gays and lesbians based solely on morality claims from the state because, quote, liberty presumes an autonomy of self that includes freedom of thought, belief, expression, and certain intimate conduct. An angry Scalia dissented, saying, quote, "Today's opinion is the product of a court, which is the product of a law profession culture that has largely signed on to the so-called homosexual agenda." And he added that Kennedy was no longer following the legal teachings of Joseph Story and John Marshall, but he was offering the aphorisms of a fortune cookie. Harvard law professor and former Scalia law clerk Lawrence Lessig said, quote, "When I worked for Scalia in 1990-91, he had a set of principles, and those principles led to principled results, which were sometimes conservative and sometimes liberal. I don't understand anymore how his jurisprudence follows from his principles." Clearly frustrated, Scalia became embroiled in one off-the-bench activity after another, with more controversy to follow. In the most controversial of these extrajudicial episodes, he went duck hunting in Louisiana with a group that included Vice President Dick Cheney and flew there on Air Force Two. Cheney was then involved in a case being argued before the Supreme Court. As we are all now acutely aware, the ethical restrictions on Supreme Court justices are theoretical at best. When Scalia was asked to recuse himself from the case, he simply refused to do so, writing a 21-page memorandum which concluded, "I do not think my impartiality could reasonably be questioned." Later, Scalia told a group that remaining on the bench to hear that case had been the proudest thing he had ever done. We learned later that this ill-advised hunting trip was hardly unusual behavior for Scalia. A Washington attorney named Stephen R. Bruce discovered through scouring Facebook and other social media sources that Scalia, whenever he was asked to give a speech, would respond by asking, "Is there any good hunting in your region?" And so he accepted scores of offers to hunt and fish in the most exclusive private hunting camps in the nation, owned by uber-rich ultra-conservatives. There he was surrounded by armed men, like-minded ultra-conservatives who were freely able to out-lobby him about all of the current issues. Scalia never mentioned these hunting trips or the source of their funding in any of his financial disclosures. The New York Times reported that between 2004 and 2014, Scalia went on 258 subsidized trips, 23 privately funded trips in 2014 alone. There is absolutely no doubt in my mind that this is where Clarence Thomas and Samuel Alito learned how the financial disclosure rules could be manipulated or completely ignored. Abruptly, after several years of controversial behavior in early 2005, Scalia reversed course and went on what journalists called a charm offensive, speaking politely off the court and inviting the press to listen. The press speculated that Scalia might be positioning himself to be considered to replace Chief Justice William Rehnquist, who was suffering from thyroid cancer. But if gaining the Chief Justiceship had been his purpose, it failed due to a kaleidoscope of events. Associate Justice Sandra Day O'Connor announced her retirement on July 1, 2005. President George W. Bush nominated Circuit Court Judge John Roberts to fill her seat. But in mid-August, the president came under siege for the failed emergency response to Hurricane Katrina, which slammed into the Gulf Coast. Then on September 3rd, Chief Justice Rehnquist suddenly died. Knowing that the center seat was the most important one to fill, the president switched John Roberts' appointment to the Chief Justice's seat without considering other candidates. Scalia was not even contacted by the White House, but interestingly, Clarence Thomas was and turned down the offer. Seeming to register his disappointment, Scalia chose not to return from a Federalist Society teaching engagement at a mountain resort in Colorado to join the rest of the justices in witnessing Roberts' swearing in. When he was later asked about the new chief's hope to inspire, quote, "a greater degree of consensus and even unanimity on the court because it, quote, promotes clarity and guidance for the legal community," Scalia said with a broad smile, "Lots of luck with that." Scalia resumed his caustic attacks on colleagues, but now from off the bench. While speaking at Trinity College in Melbourne, Australia in the winter of 2006, he attacked what he called the living, evolving constitutionalists, who were guided by the evolving standards of decency that marked the progress of a maturing society. No one could miss that he meant Anthony Kennedy and their four liberal colleagues when he called them all mullahs of the West. Now a full-blown, one-name celebrity on the court, Scalia was hailed by law blockers as being the rock star of 1 Street. He embarked on a controversial Dead Constitution tour, telling his audiences the Constitution is dead, dead, dead. He was arguing for a reliance on his founding era originalism and textualism, rather than basing decisions on the evolving standards of decency of a majority of the lawyers on the Supreme Court. When the audiences inevitably raised challenges to his Bush v. Gore decision, Scalia would respond with a smile, "Get over it." After telling a Federalist Society meeting in Puerto Rico that his living, evolving constitutionalist colleagues had what he called idiotic ideas, Scalia contrasted himself from Justice Clarence Thomas, who sought to use a different form of originalism, one based on the Declaration of Independence, the rights of life, liberty, and the pursuit of happiness, to overturn every precedent in his path. In response to that theory, Scalia said, "Look, I'm a textualist. I'm an originalist. I'm not a nut." In 2007, Scalia and his conservative colleagues came together in a few cases, using their numerical advantage to cherry pick when to ignore their judicial and jurisprudential theories and stare decisis to reach highly partisan results. This provoked reproach from their more liberal colleagues. In one dissent, when the court that same year overturned an affirmative action program for magnet school districts in Seattle, Justice John Paul Stevens, then the longest-serving justice on the court, wrote, "It is my firm conviction that no member of the court that I joined in 1975 would have agreed with today's decision." But this was just the way Scalia wanted it. In 2008, the 72-year-old Scalia ignored a 1939 precedent to write his magnum opus majority opinion in the District of Columbia versus Heller in defense of the Second Amendment's right to keep and bear arms. Scalia showed that he could hold a slim 5-4 majority by using innovative grammatical rules to discount the introductory clause of the Second Amendment dealing with the right of a state to regulate its militia. And this allowed him to create a right of self-defense, which he said was more important than the collective right of the society to arm a well-regulated militia. Critics called this verbal ploy, which overturned a nearly 70-year-old precedent, his Cheshire Cat rule of construction. Now you see the amendment's preamble, and now you don't. 2 years later, in 2010, Scalia revised his originalism theory one last time in a speech entitled "The Methodology of Originalism." Contrary to his early deference to historians, Scalia argued that as a judge, he was fully capable of interpreting words himself. In short, he crowned himself the judge of the historians. He was undaunted by the fact that no major founding era historian, not Gordon Brown and not Joseph Ellis and not Leslie Saul, no one agreed with his interpretation. Instead, as he told the press, "Anyway, that's my view, and it happens to be correct." By 2010, after the retirement of John Paul Stevens, who was replaced by Sonia Sotomayor, for the first time in history, each voting wing of the Supreme Court perfectly reflected their nominating president's party affiliation. 5 Republican appointees now outvoted 4 Democratic appointees on a partisan court. Unsurprisingly, the Supreme Court was perceived by the public as a politicized institution. Scalia, referred to now as the Fox News justice, mirrored arguments first suggested on that partisan network in some of his questioning from the bench. In the oral arguments for Shelby County versus Holder, a voting case, Scalia drew gasps when he called the protections of the Voting Rights Act of 1965 a kind of racial entitlement for minorities. One poll taken prior to the first Obamacare case found that 75% of the general public believed that the justices' decisions would more likely be influenced by politics rather than being based on legal merits. Scalia confirmed that view in his oral argument questioning when he again channeled Fox News commentary by wondering if the government could force citizens to have health insurance, if it would also be able to force people to eat broccoli. An institution that had received 56% of the general public's confidence for its work in the late 1980s now saw its Gallup poll confidence ratings ranging from 30% and hitting 40% only twice since 2007. In June of 2022, it fell down to 25%, down from 36% the previous year. With his conservative ideological bubble under attack 2 years later, Scalia returned to his old pattern, issuing 2 more scalding solo dissents in the landmark case of Obergefell versus Hodges. In the majority, Anthony Kennedy struck down state regulations banning same-sex marriage as being violations of what he called, quote, personal identity and, quote, human dignity, which he said was a fundamental right under the 14th Amendment's equal protection and due process clauses. Kennedy opened this argument by saying, "The Constitution promises liberty to all within its reach, a liberty that includes certain specific rights that allow persons within a lawful realm to define and express their identity." Of this statement, Scalia wrote in dissent, "If even as the price to be paid for a 5th vote, I ever joined an opinion for the court that began with that sentence, I would hide my head in a bag." To no one's surprise, there was no thawing of personal relations between these two 79-year-old justices in the winter of their careers. He called Chief Justice John Roberts' opinion upholding the Obamacare subsidies for the customers of state health insurance exchanges, quote, interpretive jiggery pokery, pure applesauce, and somersaults of statutory interpretation that when combined together made a defense of the indefensible. While all of this argumentative legerdemain, Scalia said we should start calling this law SCOTUS care. Now too old, too critical of his colleagues, and too set in his ways to capture the majority of his court, Scalia did not react well to these 2 losses. He told the Federalist Society audience in London that summer, "This has been the worst judicial term I've seen in 29 years." Scalia had changed from being a self-proclaimed faint-hearted originalist in 1989 to a political justice in Bush v. Gore in 2000 to a result-oriented partisan justice by 2010 from Citizens United and Shelby County versus Holder, all the way through to these Obamacare cases. And the rest of the conservative wing, despite Scalia's unwillingness to work with them, began to follow his lead in their own way. Just how do we evaluate the disruptor nature of Antonin Scalia's career and work on the Supreme Court? I think that Santa Clara University political scientist Terry Jennings Peretti has offered a way to do so in 2 excellent books about the evolution of the Supreme Court, from the neutralist court of the 1970s to becoming a political court in the ideological, politicized Rehnquist court era, both of which she says are beneficial because she wants the court to deal with political issues when nobody else will. But in the second book, an excellent book called Partisan Supremacy, Peretti sees another change in the court to become a supremely partisan body, most evident early on in the political party-directed Roberts Court in the voting rights area prior to this term. Peretti does not like these decisions at all. I believe that Antonin Scalia largely triggered this change. There are people on the court who worked with Scalia, and there were people appointed to the court by President Trump who want to be the next Scalia. They want history to record that their originalism is the best originalism. There is no doubt that Scalia will be remembered as one of the most philosophically influential and partisan political justices in our history. But Scalia never learned that one justice, no matter how loud, how brilliant, and how determined, or how uncivil, cannot control the voting majority of the court. I believe that if Scalia had followed the example of consensus-building Justice William Brennan, Rather than operating as a court of one, as I title my biography of him, his overall historical legacy might have led to this evolution to a partisan court much more quickly and made it last for a longer period of time. It was the political manipulation by Donald Trump, Mitch McConnell, and the Federalist Society that changed the court's membership from 2016 to the present. And we saw how a half century of a balanced 5-4 court has become the partisan supermajority that it is now. Now it can rule not just in a conservative ideological direction, but mirroring the Republican Party's campaign platforms in presidential elections, and doing so in a way that sometimes makes Chief Justice John Roberts almost irrelevant. But Antonin Scalia would not live to see the creation of his dream court and his ultimate goal of overturning Roe v. Wade. Indeed, his sudden death in February 2016 triggered the events that followed. It was on one of his hidden hunting trips following a lengthy tour of East Asia on a speaking tour that he died in his sleep while staying at the Cibolo Creek Ranch near San Antonio, Texas, with members of the International Order of St. Hubertus, a secretive, honorary, true knightly order under the protection of the King of Spain. This order protects sportsmanlike conduct in hunting and fishing. Playwright John Strand, in his play about Scalia titled The Originalist, startlingly accurately predicted what would happen next. In the play, Scalia returns to court from a brief car accident, and his law clerk asks him, well, what would have happened if you died in that car accident? And Scalia says with a laugh, half the country would cheer, and the other half would fight over who replaced me on the bench. The line proved prophetic. Scalia's death triggered a tectonic shift on the court, with aftershocks that continue to reverberate. After Mitch McConnell and Ted Cruz refused to allow President Obama's nomination of Judge Merrick Garland the courtesy even of a hearing in the Senate Judiciary Committee, he delayed the filling of the seat until after the 2016 election, taking away 10 months of President Obama's appointment power to the Supreme Court. Thus, he denied the Democrats the chance to change the ideological direction of the court majority for the first time in 46 years. As we all know, despite the popular vote in Clinton's favor, the Electoral College awarded 306 of its 538 votes to Donald Trump. To fill that seat, Trump selected originalist Neil Gorsuch of the 10th Circuit from Colorado from the Federalist Society list of approved nominees. And Mitch McConnell's Republican Senate majority ended the filibuster power on such questions to make the confirmation possible. Anthony Kennedy's retirement in 2018 and the subsequent death of Ruth Bader Ginsburg just 7 weeks before the 2020 election resulted in the appointments of Brett Kavanaugh and Amy Coney Barrett, and transformed the Supreme Court into an ultra-conservative supermajority. But the new Trump court was not marching to the tune of Scalia's law office history method of originalism. They were marching to the bizarre history and tradition tune of an angry theocrat, Samuel Alito, and the precedent-abhorring Clarence Thomas. These two ultra-conservatives marshaled the Trump Three to make Chief Justice John Roberts completely unable to control their votes. Untethered from the center, they invented history as it never was to overturn Roe v. Wade, eviscerate the wall of separation between church and state, turbocharge the gun rights protections of the Second Amendment, and limit the reach of the executive branch agencies by preventing the Environmental Protection Agency from dealing with climate change. Would Scalia, the faint-hearted originalist, have joined these opinions, ignoring and overturning dozens of precedents, and argue that the previous groupings of justices had been egregiously wrong in order to create the world he wanted to create? Would he have approved of the partisan rather than legal way that these opinions were written, and sent clear judicial signals to partisan litigators for their future precedent-clearing agenda? Almost certainly he would have voted to make Roberts, his judicial bête noir, powerless to stop them. But remember that by doing so, the Supreme Court would have given him, by rule, the senior justice in the majority, not including the Chief Justice, absolute power to select the opinion's writer. Does anyone doubt that one or all of the abortion, gun rights, and praying football coach cases might well have been written by Scalia instead? But there is more. Following Scalia's flaunting of the rules don't apply to me on financial ethics and public speaking, we now see a total disregard of judicial ethics by Clarence Thomas and perhaps Samuel Alito, and an unwillingness by Chief Justice John Roberts to acknowledge the problem here. The ability or unwillingness of the Chief Justice to deal effectively with ethical issues, or the leak of the Dobbs opinion, only diminishes the court and damages its public integrity. Despite the American public's currently displayed deeper partisanship and defending whatever in other eras would be considered indefensible conduct from some public officials, I expect that we will continue to see significant drops in public confidence in the court, even below its current historical lows, and that Gallup poll should be coming pretty soon. Will there be a time in the future that the majority of public opinion stops paying attention to the court completely and refuses to obey it? I wouldn't have believed I'm saying this, but I think that is now possible. And I tell my politically engaged students that in their lifetime, I believe they will see real reforms of the court. And that brings me back to Dean Alfange in our early 1970s classes. As I was preparing last year when I last spoke to you on this question, to teach my basic constitutional law and politics course last fall, I knew it was going to be a challenge, but I had no idea how much. After all that we had seen in the late June of 2022, I felt the same impulse that Thomas Reed Powell of Harvard had in 1937 after Hughes's and Roberts' switch in time that saved 9. I had to throw out so much of what I had always taught about the Supreme Court. Whole boxes of my notes could have been burned to the core, and I wouldn't have missed them because they were gone. To explain to my students how it was now completely untethered from stare decisis, traditional jurisprudence, and behavioral ethical norms. It took me a full 8 months, and I was in the end of it when we spoke in August last year, and countless revisions of my syllabus to figure out what I wanted to say. I just could not use the approach that Dean Alfange had taught us. I couldn't just concentrate on stare decisis. I couldn't just concentrate on the rule of law and respecting precedent and the need for judicial self-restraint. I needed to create a new paradigm and use different scholars and a unique approach to teach this course. I had to figure out how to teach them that they were studying not just justices, but politicians in judicial robes, who operated on and off the court as political actors, using their legal tools to change the world to fit their own vision, and why it mattered to these Gen Zers who would become future lawyers and judges themselves. How was this court employing the kind of judicial activism that Dean Alfange had warned us about, but applying it in a different, hyper-partisan, power not reason manner as decried by Justice Thurgood Marshall? As all of you teachers well know, you can make all the plans you want for your class, but students have their own ideas, what they want to hear from you and what they want to learn in a course. So I began my first lecture as I always did. Chief Justice John Marshall, 1803, Marbury versus Madison, Thomas Jefferson, John Adams, the creation of judicial review. It was one of my very best. First question from one of my star students. That's all very interesting, but how does this help us understand what was in the Dobbs abortion decision last June? Before I could answer the question, another of my star students said, and what about West Virginia versus EPA and the climate change problem? It was that moment that I realized I had to scrap the rest of everything I had planned to do and figure out how Dean Alfange teaching us could prepare me for teaching them. How could I teach the post-millennial generation about the Roberts Court and why I think it had broken in June of 2022 and why I think it might be possible yet to salvage it? It was then that I returned in my mind to Dean Alfange's college courses 50 years ago. and started explaining to my students about the Roosevelt court packing era in the late 1930s. Yes, their eyes rolled as they heard it. And I said it would help us to understand the meaning and possible danger of the Warren Court's activism in the 1960s. Yeah, that was when your grandparents were in college, I know. And now I was going to add to them the tradition that we had learned from the lessons of the making of the Nixon Court in the early 1970s to the unmaking of the Roberts Court, and that got their interest. And so I told my classes, we're going to start the way I was taught. For several weeks, you're going to learn the law by studying all of the major historical precedents. You will know everything that the Supreme Court knows about those precedents. You will know what came before the bizarre decisions of June of 2022. Through close reading and analysis, you will understand what each of the opinions in those cases say. You will learn to challenge their reasoning. You will identify and argue all sides of the issue, and we will differentiate them from similar cases in earlier eras. Only then can we analyze the current court. We need to understand that the majority of the vote in each of these cases, and then we need to compare it to the dissenters, the still, I would argue, neutralist judges who respect precedent. Elena Kagan, Sonia Sotomayor, at that time, Stephen Breyer, and now Ketanji Brown Jackson. What are they saying in their opinions? Those are the opinions that you will recognize from our reading of the earlier cases in this class. I told my students that once we get to the Roberts Court, their cases cannot be understood just as the product of institutionalist-oriented justices who respect stare decisis. They have to be analyzed as the work of politicians, both outside the court and within their institution. We have to understand that individually and collectively, they are seeking to amass power. They are trying to change the world to the way they want it to be. And in doing so, they want to build their own personal historical legacies to be remembered as the conservative justices who did this. To understand what is happening, I told them, you need to take off your pre-law hats in the Roberts Court cases, and you need to put on your political science hats and utilize everything that you have learned in the classes in Kirby Hall where we were sitting on United States politics, and apply those lessons about politics to these cases as well. And when you feel the most outraged, and when you feel lost in the angry, political, theocratic messaging of Samuel Alito and Clarence Thomas, do what I do. Try reading the cases again backwards. Start by reading the dissents of Elena Kagan and Sonia Sotomayor, and I suspect soon Ketanji Brown Jackson. See what they do with the precedents. See what they tell you about the rule of law, and understand that they believe these precedents should still exist. And then you will understand that for some on the court, stare decisis and the rule of law still matters. In counseling my young constitutional law students this way, and this system did work in 4 classes last year, I have found a very positive message that resonates in what I discussed with you a little bit last year, the work of law professor Gerard Maglioka. He combines the paradigms of American political and legal development with his undergraduate training in, of all things, military strategic theory. Maglioka has written persuasively about periodic changeovers in what he calls constitutional generational regimes. He argues that in the late Jacksonian era of the early 1830s to late 1830s, and the Gilded Age Lochner era from 1895 to 1915, there were titanic battles between combined forces of upstart reformist organizations and the defenders of the political establishment and elite. And these battles ended in fights about decision-making over legal issues. And thus they ended in fights over reforms of the United States Supreme Court. Roger Brooke Taney was able to destroy the Federalist decisions of the John Marshall Court because Andrew Jackson got 6 appointments to the Supreme Court. The reactionary conservative majority in the early 20th century beat back the child labor and workers' rights reformers and followers of William Jennings Bryan Progressive Party because he lost the presidency 3 times and conservative presidents appointed even more ultra-conservative justices who supplied reinforcements for doubling down on the earlier conservative decisions. But the anti-New Deal decisions were punctured in the court packing plan and the switch in time that saved 9. And when FDR ultimately replaced every member of that court, that was when real change began in the 1940s and continued for several decades. Maglioka argues that generational change in America represents a constant clash of two ideological armies in a generational battle between the established political regime and the rising reformers. These armies clash over what he calls issues of first principle: slavery, the Civil War reconstruction, the progressive reforms of the Gilded Age, the New Deal, the Civil Rights era, and the anti-war movements, and the issues that we see now. Since those issues are eventually shaped into legal appeals that come before the Supreme Court, and that court has been shaped by the older generation, there will inevitably be conflict over changes to that body and its operational rules. And that conflict will continue making new appointments or debating over the changing of the nature of the court as an institution. The established regime will seek to retain the status quo, while the reformers will seek to push changes forward. The older regime will use a series of controversial preemptive moves, using the law and their institution to attack the reformers and benefit the established generation in a way which sometimes perpetuates their regime. But it doesn't always work. We see all of this currently playing out in the many state restrictions on voting rights, ending abortions, obliterating the separation between church and state, and restricting or transforming LGBTQ+ rights. In analyzing the current court using this paradigm, I've read widely in American history, and still am, to try to find an era that is most like the one we are seeing now. I think we are going through a very unique generational change. We are witnessing a partisan Supreme Court that has become so extreme that it's almost routinely wiping out long-standing precedents that go back half a century. Think about it. The Janus Union case that you all know so well, ending the use of government union agency fees in 2018, wiped out the Abood versus Detroit Board of Education case in 1977. The Dobbs, Mississippi abortion case wiped out Roe v. Wade in 1973. The Kennedy versus Bremerton School District praying football case wiped out Lemon versus Kurtzman of 1971. And now we are on the precipice of what many fear will be Harvard and North Carolina affirmative action college admission cases overturning the Bakke case of 1978. Notice that all of these precedents are being overturned from the 1970s, and it's from the conservative Burger Court. Apparently, those precedents are just not conservative enough, and just not partisan enough, and just not theocratic enough for a majority of the current court. And many of the current justices have gone much farther than any in history in ignoring the court's ethical norms and rules, certainly farther than anything that Abe Fortas did, and he resigned from the court, and William O. Douglas did in the 1960s, and he was worried about being forced to resign. Press reports, as you all know, have linked two members of the court, Clarence Thomas and Samuel Alito, to billionaire benefactors, traveling the world, fishing for salmon, and vacationing on their money. Who knows what financial support of the court we will learn about next? And notice that with the leaking of the Dobbs draft anti-abortion opinion and the lack of transparency about the court's partisan work with the expedited emergency shadow docket that Stephen Vladeck writes about so well, together with the lack of the Chief Justice's willingness and or ability to lead meaningful reform, internally we are seeing an erosion in public support for the court. It is no accident that we now see proposals by Congress to expand the size of the court to 13, and by the Brennan Center to limit the tenure of the justices to a rotating 18-year term. Just where is the court going next? Are we moving into the same pre-court reform era of 1930 to 1937, the so-called Constitution in exile? Or are we going back to Lochner versus New York, the substantive due process era of the early 20th century? Or are we going back even further in time? So which side will win this generational clash? I can only hope that one or more of the Trump appointees, perhaps Brett Kavanaugh, might be persuaded to join with the chief, to reach across the partisan aisle and join with the three progressive justices to save the court from itself, to save the court from its demise. But even that will still lead to a court that is much more conservative on many issues than the general public is seeking. And it's certainly more conservative than the rising generations that we are teaching. I strongly believe that real change is coming for the court, as I said, because many of the justices have shown that they want to rule and live like emperors, and they refuse to regulate themselves. But the modern press will not allow them to hide their indiscretions. And the inquisitive public sees that beneath their judicial robes are just human beings like all of us. We need to study them. We need to teach about them. We need to understand them that way. And I believe that this is the lesson we must teach our students now. Thank you very much.